Industrial and intellectual property law. Well, what is it? We tend to refer to three main concepts, those of patents, copyright, and trademarks. The term industrial property tends to be used in respect of practical developments. It essentially relates to patents, and these might be awarded for inventions that produce some effect in the real world. Copyright is essentially related to the output of the human mind. And it's a different matter. Although it might be said that music can soothe the savage breast, music is perhaps not as effective as a tranquilizing drug. Copyright is the classic form of what we call intellectual property law. And then we have trademarks, which fall somewhere between patents and copyright. They're the product of the human mind, but their value lies in the association with some form of goods or services. No classification is ever absolute, and the tendency today is to group all of the forms of rights together under the heading of intellectual property law, and I'll tend to use that term. All of the systems date back centuries. In the 17th century, elements were highly controversial. Patents were awarded by governments for activities that were in no way novel. Effectively, people would pay bribes to receive a monopoly over the supply of basic commodities such as salt. In England, concerns about the abuse of the system constituted a significant factor in the removal of the monarch, what's sometimes referred to as the Glorious Revolution. Following on from it, the famous statute of monopolies restricted governments, at that time we're talking about monarchs, to awarding patents only in respect of developments that were novel. Novelty is, of course, a relative concept. The Chinese had invented paper and the printing press long before this technology was invented in the Western world. In our globalized world, it is difficult to imagine such a scenario, but there are complaints that some patent officers today are willing to award patents for developments that are not truly novel. One English judge has fairly famously talked in terms of the establishment of an arms race between countries in which the weapons were patents rather than nuclear bombs. A key element of the patent system is that it confers a monopoly on the patent owner. A story that I often tell relates to Alexander Graham Bell, who is renowned throughout the world as the inventor of the telephone. There was another inventor in the field, somebody called Elisha Gray, who nobody's ever heard about. He invented a telephone and applied for a United States patent. The patent system works essentially on the basis of first come, first served. And in one of history's strange coincidences, Bell had applied a few hours earlier. In fact, there are a number of reasonably well-founded conspiracy theories suggesting that Bell's patent agents may have bribed patent officials to predate his claim. We'll probably never know the truth about it. History does have a tendency to repeat itself, and that's certainly the case with patents. They were highly contentious about 200 years ago, and then around the end of the 19th century, they largely disappeared from the legal mainstream. When I studied law in the 1970s and the 1980s, intellectual property was covered in half a lecture in a course on property law. The rest of the course was concerned with rights in land and other forms of physical property such as buildings. That's certainly not the case today. We are often told that we live in the information age, and there is much said and written about information societies. intellectual property is at the heart of modern life. In this course, we'll explore some of the controversial aspects of the topic. To give a few examples, in the field of patents, we have the so-called patent wars in the IT sector, and specifically smartphones. It's estimated that there are some 50,000 United States patents that relate to different elements of the technology. It's essentially impossible to develop a mobile phone today without infringing patents. Another field of controversy relates to pharmaceutical products. The development of drugs can be a very expensive undertaking, but once a workable formula is developed, it can be replicated very cheaply. This has become a controversial topic. Patents are valid in the country in which they are issued, but there are mechanisms for a patent awarded in one country to serve as a springboard for an award in others. Until fairly recent times, patent systems have existed in first world countries, but the establishment of the World Trade Organization has brought significant changes. In order to benefit from access to global markets, developing countries will be required to sign up to the TRIPS, Trade-Related Aspects of Intellectual Property Rights, Protocol. This requires the establishment and enforcement of patent rights. These patent rights are often owned by first world countries. And I think you can see the arguments for and against patents. They are designed to encourage innovation, and that benefits us all. But the monopoly protection given by a patent may inhibit competition, and in the case of pharmaceutical products, may prevent access to drugs at an affordable price. In fairness to patent owners, some significant steps have been taken to improve accessibility. But remember also the Alexander Graham Bell story. Elisha Gray could not utilize an invention because Bell had a monopoly. The patent monopoly lasts for a limited period of time, 20 years at most. When Bell's patents had expired, others could enter the market. But his company by that stage had an established network, and entry barriers were insurmountably high. This still brings us to a linkage with trademark law. Trademarks are essentially about reputation. They are brand names that we trust and may pay extra for real or imaginary reassurances to quality. You can see an example in any pharmacy. You can buy unbranded aspirin tablets for very little money, or pay very significantly more for a branded product. The two drugs are identical. In many cases, the developers of a patented pharmaceutical product will invest heavily in trademark protection. Trademarks can last indefinitely, and the hope in reality is that when the patent expires, consumers will continue to purchase the branded product that they know and recognize, rather than an identical and cheaper generic version which has to be sold under a different name. Last, but certainly not least, a few words about copyright law. In many respects, it's the simplest form of intellectual property right. Record anything, words, music, pictures, and it's protected by copyright, irrespective of how good or bad it is in qualitative terms. Different forms of work get different levels of protection, and that's an issue that will be explored in the module. In some ways, that's the easy part. As with many aspects of life, the internet, and at a broad level, the move towards digitization changes everything. if you think of using a photocopier, the quality of the copy that you made will be inferior to that of the original. If you then copy the copy, quality will diminish further. Compare that with copying a Word document. The copy will be identical to the original. And one of the key issues that we're facing today is that the distinction between copy and original largely disappears. Again, copyright infringement. If you wanted to infringe copyright on a large scale, you needed to invest heavily in equipment, printing presses, mass production facilities. No longer. We can all upload or download information to the internet. We're all potential copyright infringers. And we have the question, who's liable? If we upload information, we're potentially liable, but we don't have any money. And a lot of the concern these days talks about liability of third parties. Who's responsible? At one level, we have companies like Google. Enter a search term into Google and you'll get access to information. Is Google liable if the information that you get access to is infringing copyright? It's a difficult question. We've got the likes of Google, and we've also got, perhaps at a more blatant level, third-party sites, file-sharing websites. We're probably all familiar with file-sharing websites. And we know sites that are perhaps dubious. And where does the distinction lie between knowing that material is illegal or thinking that material is illegal or deliberately turning, we tend to refer to as a blind eye to infringement? So there are important issues in this respect. There have been developments in the UK in recent years with right owners going to the courts seeking to compel intermediaries to block access to file sharing websites, which predominantly contain infringing material. And there have been about 500 cases in the last 5 years. So again, an important issue. Intellectual property started in probably around about, you'd never tell the time exactly, around about the 14th century. It was controversial. It disappeared from the legal mainstream, and now it's firmly back in the legal mainstream. We live in information societies, and it's important to us all.